5 seconds to go. Start. The whole object of granting compassionate employment by an employer being intended to enable the family members of a deceased or an incapacitated employee to tide over the sudden financial crisis. Appointments on compassionate ground should be made immediately to redeem the family in distress. See Susma Gosain versus Union of India. Since rules relating to compassionate appointment permit a side door entry, the same have to be given strict interpretation. Compassionate appointment is a concession and not a right, and the criteria laid down in the rules must be satisfied by all aspirants. None can claim compassionate appointment by way of inheritance. See State of Chhattisgarh versus Dhirjo Kumar Sengar. Appointment based solely on descent is inimical to our constitutional scheme, and being an exception, the scheme has to be strictly construed and confined only to the purpose it seeks to achieve. None can claim compassionate appointment on the occurrence of death, medical incapacitation of the concerned employee, the sole bread earner of the family, as if it were a vested right, and any appointment without considering the financial condition of the family of the deceased is legally impermissible. See Union of India versus Amrita Sinha. An application for compassionate appointment has to be made immediately upon death, incapacitation, and in any case within a reasonable period thereof, or else a presumption could be drawn that the family of the deceased incapacitated employee is not in immediate need of financial assistance. Such appointment not being a vested right, the right to apply cannot be exercised at any time in future, and it cannot be offered whatever the lapse of time and after the crisis is over. See Eastern Coalfields Limited versus Anil Badiakar. The object of compassionate employment is not to give a member of a family of the deceased employee a post, much less a post, for post held by the deceased. Offering compassionate employment as a matter of course, irrespective of the financial condition of the family of the deceased, and making compassionate appointments in posts above class 3rd and 4th is legally impermissible. See Umesh Kumar Nagpal versus State of Haryana. Indigence of the dependents of the deceased employee is the first precondition to bring the case under the scheme of compassionate appointment. If the element of indigence and the need to provide immediate assistance for relief from financial destitution is taken away from compassionate appointment, it would turn out to be a reservation in favor of the dependents of the employee who died while in service, which would directly be in conflict with the ideal of equality guaranteed under Article 14 and 16 of the Constitution. The idea of compassionate appointment is not to provide for endless compassion, satisfaction that the family members have been facing financial distress and that an appointment on compassionate ground may assist them to tide over such distress is not enough. The dependent must fulfill the eligibility criteria for such appointment. There cannot be reservation of a vacancy till such time as the applicant becomes a major after a number of years, unless there are some specific provisions. Grant of family pension or payment of terminal benefits cannot be treated as substitute for providing employment assistance. Also, it is only in rare cases, and that too if provided by the scheme for compassionate appointment and not otherwise, that a dependent who was a minor on the date of death incapacitation can be considered for appointment upon attaining majority. An appointment on compassionate ground made many years after the death, incapacitation of the employee, or without due consideration of the financial resources available to the dependent of the deceased incapacitated employee would be directly in conflict with Articles 14 and 16 of the Constitution. Dependents, if gainfully employed, cannot be considered. The retirement benefits received by the heirs of the deceased employee are to be taken into consideration to determine if the family of the deceased is left in penury. The court cannot dilute the criterion of penury to one of not very well to do. Financial condition of the family of the deceased employee allegedly in distress or penury has to be evaluated, or else the object of the scheme would stand defeated, inasmuch as in such an eventuality any and every dependent of an employee dying in harness would claim employment, as if public employment is heritable. The terminal benefits investments monthly family income, including the family pension and income of family from other sources, viz. Agricultural land, were rightly taken into consideration by the authority to decide whether the family is living in penury. See Somveer Singh Supra. The benefits received by widow of deceased employee under family benefit scheme assuring monthly payment cannot stand in her way for compassionate appointment. Family benefit scheme cannot be equated with benefits of compassionate appointment. See Balbir Kaur versus Sale. The fixation of an income slab is, in fact, a measure which dilutes the element of arbitrariness. While undoubtedly the facts of each individual case have to be borne in mind in taking a decision, the fixation of an income slab subserves the purpose of bringing objectivity and uniformity in the process of decision making. See State of HP versus Shashi Kumar. Courts cannot confer benediction impelled by sympathetic consideration. See Life Insurance Corporation of India versus Asha Ramchandra Ambedkar. Courts cannot allow compassionate appointment dehorse the statutory regulations instructions. Hardships of the candidate does not entitle him to appointment dehorse such regulations instructions. See SBI versus Jaspal Kaur. An employer cannot be compelled to make an appointment on compassionate ground contrary to its policy. See Kendriya Vidyalaya Sangathan versus Dharmendra Sharma. It would be of some relevance to mention here that all the decisions referred to above are by coordinate benches of two judges. Before moving on to decide the issues emerging for our decision, we may briefly refer to an area which till a few years back was grey and continues to be so. It is on the question as to which rule policy scheme would be applicable for consideration of an application for compassionate appointment, that is, the rule policy scheme prevailing on the date of death or the date of consideration of the application. Divergent views have been taken by coordinate benches of this court, and some such decisions are noted hereunder. In Abhishek Kumar versus State of Haryana, it was held that since the appellant had sought for appointment on compassionate grounds at a point of time when the 2003 rules were not in existence, therefore his case was required to be considered in terms of the rules which were in existence in the year 2001. In Canara Bank Supra 2, it was held that claim for compassionate appointment under a scheme of a particular year cannot be decided based on a subsequent scheme that came into force much after the claim. Stop.